day. Welcome everyone. Thank you for joining us today. I'm Farisha, Assistant Professor, Department of English. It gives me a great pleasure to extend to you a warm welcome on behalf of the Department of English in association with the Intellectual Property Rights Cell, IPR Cell, KAPILA, IADC and IICMS Punani College. We are organizing a webinar on intellectual property rights and copyright under National Intellectual Property Awareness Mission. Before the formal start of the program, let's go for a silent premiere. Thank you all. Invite Ms. Anupama, Head of the Department of English, Ms. Manani College, to formally welcome the garden.
Good morning, all. The Department of English, in association with the Intellectual Property Rights Cell, MES Panani College, is organizing a webinar on intellectual property rights and copyright. I welcome each and everyone gathered to this webinar. First of all, I would like to welcome our principal, Dr. V.U. Amira, to this session, who is always a strong supporter for all our endeavors. I would also like to welcome Ms. Ruchi Kumari, resource person of the day, who is also the NIPAM officer and patent patent and designer, NIPAM. I welcome you, ma'am, to the session.
Thank you. Thank you, ma'am.
I welcome all my colleagues. We are having here the economics department. I welcome the colleagues of economics department and English department, and I welcome all our students to this webinar. Welcome all once again. Thank you.
Thank you, ma'am, for your honest welcome address. And now for the presidential address, I'm profusely elated to take an opportunity to invite Principal Dr. Amira Viyu. Hardly need any introduction. I would like to request you, ma'am, to give us your precious words for today's program.
Respected Chief Guest Ruchi Kumari, IPR Coordinator Soumya, Program Coordinator Farisha, English Department Head Anupama, IIC Coordinator Jairam, IUDC Coordinator Nusrat, other faculty members, and dear students, good day to all. Let me appreciate everyone for the efforts you have taken to coordinate this webinar. As we all know, the creation and sharing of knowledge and ideas are essential for the progress and growth of a society. In the current digital age, it has become easier than ever to access and share information. But as we are well aware, this ease of access also brings with it new challenges. In protecting the intellectual property rights of citizens and owners,
Can we please talk about the economic and political state of the world right now?
I'm sorry.
I have a question.
Yes. This is it's a request. This is just
I know.
question. So we can do. We'll have a time for this question and answer session. Time. Is it okay?
Ma'am, please continue.
Farisha, shall I continue?
Ma'am, please continue. There are interrupters here.
Okay.
So we are removing them.
As academic community, we must try to uphold intellectual property rights and copyright laws. By doing so, we are protecting the works of creators and owners, and we are also contributing for a culture of respect for intellectual property, creativity, and innovation. And we have an expert guest here. Ms. Ruchi Kumari is in a NIPAM officer. I too would like to welcome her on behalf of our college, and I'm sure she will be delivering an enlightening talk. Over to you, ma'am.
Okay, so shall we start now?
Introduction.
Yes, ma'am. You can
Ma'am,
start
there is
now.
an introduction.
Now, without further ado, we will turn the time over to Ms. Ruchi Kumari, patent examiner and accomplished professional in the field of computer science and technology. Ms. Kumari completed her BTech in computer science and technology from RPDF Bhopal and went on to pursue her MTech in information technology from the prestigious Indian Institute of Engineering Science and Technology, Shibpur. Ms. Kumari has gone on to make a mark in her field and currently serves as an examiner of patents and designs in batch 2019 at the Patent Office, Chennai, Ministry of Commerce and Industry, Government of India. Her work involves evaluating patents and designs to determine their novelty, inventiveness, and usefulness, and providing expert opinions on intellectual property rights. Ms. Kumari educational background coupled with her extensive work experience in the field of intellectual property rights makes her a valuable resource for anyone interested in pursuing a career in this area. We are thrilled to have her with us today to share her insights and expertise on this important topic. A pleasure and honor to you, ma'am.
Ruchi, ma'am, over to you, please.
Okay, so let's start with the session. Um, as ma'am has already introduced, that we are conducting a session, NIPAM. It's a national awareness IP awareness mission, and through this we are trying to get give the awareness about the intellectual property right. So it is our try to get to the basic, like in school level, college level, so the kids with their developing minds can apply can they just take the interest in these IP rights. So at the last of this session, we'll know about what is uh, what is IP rights, how to apply it, where to apply it, and how can we get advantage over this. So we'll start this. Okay. Mm. So this is my humble request to everyone. Uh, if you want to share this slide, so please get a permission from our office. And this is not part of PPT material, audio, video. It shall be recorded or produced or copied or stored in any form or by any means without the written permission from Office of CGPTDM. This is just for a disclaimer. And our uh, today's our view will be on these following things, like what is intellectual property rights, significance of IPR, type of intellectual property, IP, where you see wherever we can look, IP is everywhere. Patent filing procedure in India. What is the patent filing procedure in India? What are the criteria we have to apply during the filing the patent? Research paper and what is the difference between research paper and patent? And we'll have a small quiz session at the end of this entire session. So first of all, I would like to tell you that please can you give a look into this slide. This is Facebook. It's a very famous social media, and it was in the recent news that Facebook had changed its name to Meta. So we so everything that comes into Meta is like Facebook, Instagram, and WhatsApp. Everything will be named as Metaverse. So in this Metaverse, like in this Facebook CEO Mark Zuckerberg, he had paid $60 million for just to change the name. See, what is the advantage over this? Making any right, like if you are applied for right, so what could the benefit from that? See, there was a this Meta platforms made a key strike in its key brand from Facebook, acquiring the exclusive right to the name Meta from the South Dakota bank in rupees dollar sorry 60 billion transaction. South Dakota based name Meta Financial Group said that's the Security and Change Commission filing. They sold it all the Meta trademark assets. So this could be the benefit of giving the rights. And this Kantara, we all have seen this very famous movie Kantara. So Kantara makers face allegations on plagiarism. Kerala banned Taikudam Bridge to sue the copyright infringement. Actually, there was a song. There was a song that is used in Kantara movie. That song has its copyright. So that the owner of those song rights, they filed an infringement case. They sued the Kantara movie. So here we can see that uh, because uh, because of the IP rights they have, the copyright they have, they sued this famous brand Kantara movie makers. They the thing is that here in if you are having any right, then no one are allowed to use it without your permission. It is a very simple thing that if anyone want to use any kind of thing that is already been uh, given right to someone, they have to take permission or they have to buy that right before using it into their personal use. There is one there was one example of Amazon's one-click patent. See, Amazon one-click patent was a big hit for the Amazon brand. But the thing is that every 20 years, the this thing has to it get public till certain period of time. You have the right. You can use it or you can use for your own benefits, or you can give any license to others, but after that period of time it become public and anyone can use that. So after getting over of that time period, Amazon one click patent uh, got to everyone, and because of that everyone got advantage over that. Okay, so we'll start with the very small introduction about this. uh, this is what is intellectual property right. So, IP, intellectual property, means the property which is created with intellect, such as inventions, books, paintings, songs, symbols, names, image, or design used in business. Legal rights conferred on such property are called intellectual property right, and IPR are territorial in nature. These are very basic points in the IPR. Intellectual property right are a legal right and it has a territorial boundary. What what it means is if a person he got any right, protection right in India, so he cannot claim the same right in other country also. other than India. If some person is from USA or Europe and they have got any patent right over some invention, so they also cannot claim their right over that patent in India or any other country other than the territorial boundary of that particular invention. I hope this is clear to everyone. So next is protect your intellectual right. So what is the significance? This is protect your intellectual right is like anytime in India, what is India is famous for the show of thing. We all know that, and if anyone has done something creative, they go to public first. They don't care their right, their creation, their mind creation is protected or not. First of all, it should be legally protected. Then you should go any kind of public. So this is a very important thing to keep into mind. That if any basic person, it's not like some person which very good this degree PhD holders, research person, they only can make any invention. Invention is a very basic thing. Small thing can be invented from a very which is in uh, they are very old or young people. Anyone can invent, and first of all, they should go for the legal protection for that creation. Then only go to public. What is the significance of IP right? So, significance is IP right is your it protects your invention first of all from anyone, and they exclude others means without your permission. Without your permission, you cannot. No one can use it. See, IP can be used. Like I want to give you an example. You got a flat in any city like in Chennai, you got a flat. It's in your right. Your right. The flat has every legal papers. You have this for the flat, and you can use in different ways. Like you can give it on rent, or you can use it for yourself, or you can commercialize it and sell it. So similarly, the IP has the same concept. IP is like you can use it for your benefit, or uh, you can give license to other, or you can sell it off for your any your advantage. Next is what does IP right? IP what does intellectual property offer? So these things are due recognition and awards, rewards. It also provides you the royalty, the incentive, and it is commercially sold without fear of copying. You can sell it also. They're the genuine and original product. New invention, new market, new business, increase the value of college, faculty members, students, economical growth of the country and world. So these are the following things that intellectual property offers. Either you can use it for your own benefit, or you can sell it, or you can franchise it, license it. It adds some very uh, powerful things to your CV also. Your college, your faculty member, they also get recognized for your work, and also it gives the economical growth to our country and the world. So next we are going to discuss the type of intellectual property. There are various type of intellectual property like patent, design, trademark, copyright, geographical indication, semiconductor integrated circuits, layout design, and other types of IP. We'll discuss it one by one, everything in detail. So let's go with the patent. What is patent? So patent is See, this is a chart of how it is getting rising day by day. See, in China, 1.4 million patent is there. This is a record of 2019. In USA, we can see that China is on the top level, and our position in this list is seventh. But we can see that here, India has increased the number of patent. No, by the 7.1%. In India, ranking was in 2015. India's ranking was 81. Then 2021 it got 46, and 2022 it got 40. See, by this ranking improvement, we can say that people are getting aware of these things. Thing is that it's not like in India, people they have less creativity or they have a very poor mind. No, it's not like that. It's things that we are very creative. We know how to make things useful. We know how to make new things, how to make inventions. But thing is that we are not aware of getting it legally protected, just like a land, just like a home, and other physical properties like our mobile phone or anything. But it is the intellectual thing, and we have to protect this also. And thing is getting easier. Thing will get easier if we get awareness about how to proceed for it. So, what is a patent? A patent is an exclusive right granted in respect of an invention, which may be a product or a process that provides a new and inventive way of doing something or offers a new and inventive technical solutions to a problem. A purpose of the patent system is to encourage inventors to develop the state of technology by granting them special rights to benefit from their invention, giving exclusive right to a patentee to stop others from making, using, exercising, vending, and importing an invention for a limited period, 20 years, in exchange for disclosing it in a patent specification such that anyone trained in the art can reproduce the invention. Right to exclude others using your invention. See, patent is an exclusive right. Exclusive means, what makes it exclusive? It means that this patent, it is given to you only. You means you can prevent other from making it, using it, exercising, vending, importing anything. Without your permission, no one can use it. And if they are using it, it's totally up to you. You are letting them use, or you can go to the court and sue them. So, and invention is for a limited period of time. It is 20 years. See, I would like to focus on this slide. There are two different type of inventions, and both of them are one is very basic one, and another is very advanced. So by this slide, I want you to know that inventions is not like it should be a complicated thing. This can be a basic thing also. See, the child, this infant is this cap. It is protecting the infant eyes. The water could not get into his eyes. So this is a very small invention, but very useful things. The thing is that any invention that is being useful to make any kind of solution to a problem, that is an invention. And in the same slide, we can see a very complicated and an auto driving car, vehicle, automobiles. So this is also invention, and this cap is also invention, and both can be legally protected if we are legally protected for their creativity and their for invention. Next is invention. They are in various field, like an automobiles, like textile, like this, like if you have any kind of creative motion, like a Michael Jackson. You know, very it's things that humans can bend to 20-degree, but Michael Jackson, he used to bend till 45-degree. How was that possible? And he got that right through the he has got legal right over this this movement. It was just a very simple idea, or you can say that creation from their team, and from him that there was a small nail inside his boot that was whenever he wanted to tilt to that point, he goes to that particular area and lock his shoe with that nail and use it for bending. So this was a very unique thing and a very creative thing. So he applied for the IP right and he got it. Next is IP. IP is everywhere. You can see the in the medical field, in the pharma, in medical, in automobiles, everywhere that IP is there. Thing is, next is we'll take a look into the transformation of a telephone. See, earlier time, the mobile phone, there was not a mobile phone, it was a telephone. We use telephone to communicate with any person who are far from us, and very slowly, the technology got advanced, and the reform got it. This from telephone it become mobile phone, and see now just a palm size mobile phone is there, and we can move here to there or anywhere without phone. No need to think about when we have to use the cable, or we don't have connectivity or anything like that. So this got the legal this got the this is a technical advancement. The thing was that it was being used for basic thing for the communication, but the technical advancement got the slowly it got the technical advancement over the over the same invention, and this advancement, it leads to leads to the phone we are using it now. So there is a very interesting thing here. You know, we all know who is the father of telephone, the inventor. So it is Alexander Graham Bell. So Alexander Graham Bell applied for a patent for a telephone on February 14, 1876. So then, only a few hours before, another inventor named Elisha Gray handed in his application for a telephone as well. So just in a period of few hours, Alexander Graham Bell, he applied for the patent right earlier, and just another after few hours, another person came and applied for the same this telephone. But what happened? Alexander Graham Bell, he got the priority over the Alicia Gray. So, had the Bell waited one more day to apply for the patent, Alicia Gray would today be the considered the inventor of telephone. So this is the significance of getting a IP rights. It can totally change the history. Next is let's say we are taking a phone, and if we see that there are various kind of applications and advancement of technology in this phone, such as see it has viewing, editing, saving Microsoft documents, a removable memory storage card, local wireless network connectivity, electronic circuit that execute programs on the Galaxy, mobile operating system, Android OS, protective glass screen Gorilla. So a smartphone like a Galaxy S5 includes hundreds of thousands of patented inventions. One single device can have 100 of patented inventions. Okay, so we'll start with what is design now. Design, as we can see in this slide, Design just it's a visual effect. This is a bottle, cleaning bottle. Design is ornamental or aesthetic aspects of an article. Features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional or in both forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combines, which in finished article appeal to or are judged solely by eyes. So design is a very simple concept. It is judged solely by eyes. So anyone can differentiate in design. Everything has its separate design. A cooker has separate design. A jewelry has a separate design. A stand has separate design. Similarly, clothes. Every clothes has a different colors, different design, different materials they have used. Shape of bottle. See, there is only one thing inside the shampoo, and many other kind of bottles is there, different size bottles there. Next is trademark. What is trademark? A sign capable of distinguish the goods or services of one enterprise from those of the other enterprise. Trademark is like any company or enterprise who are using a symbol to represent their company or their enterprises, their business. That comes in a trademark. You have to apply it for registration to register the trademark. Like, see, we can see here various trademark designs, trademark, like for Nike, McDonald's, Adidas, Puma, uh, Blue Cards, everything, Indian Post. The subject matters of trademark is it can be a brand name, it can be a tagline, that is slogans, it can be a sound mark, line drawing of MGM, Britannia, it can be logo, combination of colors. So like Nike has its trademark as well as it has a slogan, just do it. McDonald's has its own slogans, I'm loving it. LG has its own slogan, life's good. Everything has its own slogan. So this can also be taken as a trademark. One of the most important IP from commercial point of view is not just a name, symbol or logo. It actually the identity of a brand. So see, brand identity. We know the brand. We know that, like, if we are going for a shopping and we are buying shoes, so we know it's a Puma brand or Nike brand. We are just buying it, but unless until if see the importance of that small design over that shoe, one tick mark, it identifies that it's the shoe of Nike brand. So that name or symbol or logo, it represent all the brand, it identify the brand, distinguish the sources of the goods or services of one trader from others. So it's just a distinguishable thing. You can distinguish. Okay, this if the tick sign is there, this is Nike brand. If this some other design is there, so it is Puma brand. Any other things similar. Allows a business entity to build public goodwill and brand reputation. Assures customers about the quality of goods and services. Make sure to have a trademark if you are having a startup. So if you ever get an idea of your startup and you are just going into a business, so make sure you apply for trademark so that it identify your company, your startup. It can be anything, it can be a name or symbol or logo or slogan, anything. So this is how to indicate your trademark. Say if TM is there, it means it has been filed for trademark application, and there's a R under a circle, then it is symbol of registered mark. Next is I would like to find. I'd like you to find some famous trademark over this puzzle. Anyone can you tell me any brand name you can see here? Okay. See, this is Pepsi, Amul, Tata, Horlicks, Link, Bata, the so many, Babool, Dettol, Lux. These all are trademark sign, trademark. And we all know that anything can be copied. So some of us, what they do, instead of Puma, they will write Puma. Instead of this lady, they write this lady. So be aware of that. And yes, if you are going to buy something and you want to be original brand, then take care of these signs and take care. Just know the sign and the slogan. Then only you can identify it is original or not. Next, we will go for copyright. What is copyright? And a copyright is an exclusive right, exclusive legal right granted to creator on expression of an idea. Copyright owner has right to produce, translate, adapt, perform, distribute, and publicly display the work. Registration is not mandatory since copyright comes into existence as soon as the intellectual work is created. It is recommended to register a copyright for better enforceability since registered copyright have evidentiary value in court. So, what is in a simple word, copyright is an expression of an idea, and the copyright owner has the right to produce it, translate it, adapt publicly. They can work in publicly display also. Registration is not mandatory since the copyright comes into existence as soon as intellectual property work is created. And yeah, so it is very important thing to keep into mind that copyright is also valuable as an inventory value in court. And these are some example of copyright, like literary works, paintings, photographs, drawing, films, music, choreography, sculpture. This all comes into copyright. You can apply for if you have a painting and very famous Picasso paintings are there and they have a copyright. Photographs, so many photographers are there and they have the copyright for the photographs and the drawings. The films, you can see that frames have the copyright and songs have copyrights. If you are using that, if you're copying that music or songs and you are writing, you can do so. If you are not, if you have not got a permission from that owner. So everything has its turn. So if a it is a work of literary, dramatic, musical, or artistic work. This is the lifetime of the author and until 60 years from the death of the author. And if it's anonymous or pseudonymous work, then it's 60 years from the year the work was first published. If it is a work of public undertaking and government work, then 60 years from means uh, other than literary and musical, artistic work, everything has it's 60 years from the years in which the recording or it got published. So if it is literary, it is like music and any books, any dramatic books, anything is there. It's the term for this will be a lifetime of the author and until 60 years from the death of the author. So next type of our IP right, it's SICLDR, that is Semiconductor Integrated Circle Layout Design Registry. Like semiconductors, these are fabricated from the complex series of layers of semiconductors, metals, dielectrics, insulators. Whatever we are using, like we are using phone or a computer system or any musical device or processor, everything. It is the chip It is an integrated circuit layout design that is being used in that, and so that we can proceed for our work. So this comes in semiconductor integrated circuit layout design. Next is geographical indication, GI tag, that we are very much familiar with GI tags. Like it is an example. Geographical indication is a sign used on products and have a specific geographical origins and possess qualities or a reputation that are due to that origin. So it is a uh, GI tag is given in a group. It cannot be given to some individual person. So it comes into a group of person, and any special origin, geographical origin is there, and they are known for their qualities, and they are known for their design, anything is taste. So that reason, or that group of family, group of person, they get GI tags. Like Tirupati Laddu, it has got its GI tag. Kanchipuram silk, and then Nilambur teak, Mysore sandal soap. They are the very famous in their geographical origin. So they get they have a individual significance. So they get a GI tag. Some other examples are Kashmir saffron, Darjeeling tea, Kodaikanal hill garlic, Pokali rice. Other types of IP are also there, like plant varieties. It comes into Ministry of Culture. Like many of our Indian farmers, uh, they experiment and use it for the plant varieties. They use it to make a creativity to their farmer life. So they also get an IP, intellectual property right, and it comes into the under the Ministry of Agriculture. Like a trade secrets. Trade secrets are these are the secrets that are not actually disclosed by some traders, like KFC chicken, or some other what do we call that? People who make dishes, they have a secret ingredient or secret procedure, but they don't want to disclose it. So it comes into trade secrets. Traditional knowledge. Traditional knowledge also have their very significance in the in India. Like you can see the use of haldi, turmeric. It is a traditional knowledge. It has come from the very earliest time in our country, so it comes into traditional knowledge under IP, right? So IP is everywhere. uh, how to no claim it? How to see IP is everywhere? If you are just taking one device, like a laptop, you are taking a laptop, you can identify so many of IP rights just in one product. Like there is a logo of Apple. That logo, it comes into trademark. See, this is a screen display, LED display. That is also patentable. That body type, the shape of body, it is a design. This the layout of IC, integrated circuit, that is SICLD. The usual manuals is given in every devices, like how to use it, how to proceed, where to go to if you want any help. So that is manual, user manual. So this it is just to help the user to go through all the working of devices, how to work the device. So that is user manual. That is also copyrighted. So in the single device, you can see the many number of IP rights. Uh, I will discuss about the validity, because everything has to everything has its period limit, time period limit. Like patent has 20 years term. There is nothing called global or international patent. Like I have already told you, patent is a territorial right. Means if you are in India and you got an IP right over your invention, you cannot claim the same right over that invention in other country. Uh, Design has 10 years plus 5 years if you are giving the license fee. And trademark is a indefinitely. Trademark is indefinitely subject to renewal initially for 10 years. So every 10 years, you have to give a renewal fee, so you can renew your trademark right. GI tag is indefinitely subject to renewal initially for 10 years. Initially for 10 years, it will be there, but after 10 years, you have to pay renewal fee. Similarly, copyright, I have already told you, for the artistic, literary, and musical work, it is a life for the lifetime of author, and plus the 60 years after the death of that author. Who can apply it? The person individual, not for GI or legal representative. Who can apply for these rights, patent rights, design, trademark, GI? So, except GI tag, anything can be applied individually, but GI tag is a group or regional tag, regional right. Person, it includes like any firm can apply. Partnership, in partnership also you can apply. If you are two-person in that similar invention you are working, and both of you apply for the invention, then also you can apply for both. You both can apply for invention. Similarly, a small entity and a body, corporate office, also any company can apply for, any college can apply for, any entity, any individual. All IP rights are, every right is territorial in nature. It should be minded. Uh, so next is what a type of work is there. Patent, invention or innovation, duration is 20 years, like we have already discussed this. Design is aesthetic, ornamental or non-functional features of an article or product, and it is 10 years plus 5 years renewal. Trademark is distinctive signs or mark to identify or distinguish goods and services, that is indefinite time and renewal every years, renewable every 10 years. Copyright is artistic, literary, and musical works, sound recording, films, and broadcast derivatives work, and it has a duration of lifetime of the author plus 60 years. And for everything else other than this artistic literary work is 60 years. Geographical indication is a product originating from a specific location, which gives that a product a unique and differentiating quality. This is also for the indefinite time, but every 10 years, you have to pay a renewal fee. And SICLD is a layout of transistors and other circuitry elements designed to perform an electronic circuit function, and it is given for the 10 years. So there are some points to remember, that first protect, then publish. Whenever you have created something very good and a very new thing, so it should be protected first. Go to the patent offices or anywhere and apply for the right. Apply for, save it first. Rights are territorial, limited to the boundary of country or sovereign authority. Registration is required in each country. Registration is done by sovereign authority, that is in India it is Government of India. Right for limited period of time, and no automatic relief, no need to file infringement suit. Renewal fees to be paid for some IPRs. Next is we'll have a small question session. I have a question for you that you have to give answer for that. Which type of IP protects the painting painted by artists? Anyone can tell me? Anyone? Okay, so this the answer is it is painting. See, we can see it is written painting painted by artists. So artistic works it comes into copyright. So answer will be copyright. The next question is, what protects the intellectual property created by fashion designers? So it is very easy questions. There are its answer. Anyone can give me the answer?
Registered designs.
Yeah, completely correct. Thank you. Next is, which of these is a geographical indication? BMW, Venkat Giri Sari ironing machine with a stem, PlayStation, World Wide Web. So very easy question. Can anyone give me answer?
Venkateshwari Sari.
Very nice. Very it's a correct answer. Similarly, we have our next question. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? So, what could be the answer? Anyone?
Trademarks.
Yeah, correct. Because he is owning a company and he wants something to represent its company, his company. So it is a trademark. He will apply for some logo or any slogan for his company, and that comes in trademark. Next is, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? So, anyone can answer that? It is developing a new technology. It's a new invention.
Patents.
Yeah, very correct one, because it is giving us some advancement over some product. So it comes into patent because it's a new thing. It's a similar, if it is a similar invention, but you are giving a technical advancement over that, that is also comes into patent. Or it is a new, completely new invention is also there, so it will come into patent. This is see, we got introduced to from all the IP rights, like what is patent, what is design, trademark, everything design. So next is where to approach for patent. If you have got any invention, you did some kind of copyright thing, or you have painted something, or you have wrote a song something. So you know, on the next you have to go for the IP rights. So where you can approach for that? Nowadays everything is online, so you don't have to go for the physically filing. You have to go to say some Chennai office or Kolkata office. No, you can use it over, you can go to your computer system and you go to a link and you will see there. You have to you can fill the forms and everything. So for the for copyright, you will there is an office in Delhi. So in Delhi office you can apply for copyright registry. For this trademark we have five offices: Mumbai office, Delhi, Chennai, Kolkata, and Ahmedabad. For design, you have to apply in Kolkata. For patent, you have to apply in Kolkata, Delhi, Chennai, any of these four offices. For there is a one Rajiv Gandhi National Institute of Intellectual Property and RG the IPS. So here there also you can contact, and for GI tag you will have to apply in Chennai. SCICLD you have to apply in Delhi. Patenting procedure in India. So you got the idea of IP rights, and you got this also, like where to apply it, and now the time is how to apply it, how to proceed in India. So there is a particular process. Simple graphical representation of this is a simple graphical representation of patent granting procedure. This is how we work here in India. Like first of all, there would be a filing. If some inventor or any application is coming to file is to file for the grant, file for their IP rights. After some time, it will get published. Then it will get examined. Then it will, this examination portion, it comes to us. We are the examiner of patents and design. So after publication, if you are applying for examination, then it will come to us. I will examine it. Will make a report over that, and then it will go for grant. Application grant. So uh, and this granted application will be published. It is a final publication. So there is an opposition. There is called one thing opposition. Opposition means like if person one has come with his invention and he try to get a grant over that patent, grant over that invention. So opposition, if some person two is there, it you applied for the grant, you applied for it IP rights, and it got published. After publication, it go public, and if some person two is there, and he is so much convinced, or he is so much like into he think that it is his invention, he has already right over that kind of invention. So he will file a opposition. He will file a opposition, and an opposition, it can be at the two stages. It can be pre-grant opposition or it can be post-grant opposition. Like after the publication of your file, your application, if someone is going to opposition, he can apply pre-grant opposition. It is before the grant, and one is post-grant. Even though you got a grant over your invention, then also under 1 year, if someone is coming and is claiming that no, this is his invention, he has right over that invention, he can go for post grant opposition. I hope this is clear to you. Appropriate patent office. So this is just jurisdictions. Like in Mumbai, if any person is staying in Goa, Gujarat, Maharashtra, Mumbai, Daman, Diu, Dadar, Nagar Haveli, Chhattisgarh, they can apply. The nearest will be jurisdiction comes in under the Mumbai office. Similarly, if someone is staying in Andhra Pradesh, Telangana, Karnataka, Kerala, Tamil Nadu, so it comes into Chennai office. Then Haryana, Himachal Pradesh, Punjab, Rajasthan, Chandigarh, Delhi, Jammu Kashmir, Ladakh, it comes into New Delhi jurisdiction, and rest of the northeast side, it comes into Kolkata. So there are types of application. Thing is that will go from step to step. You know about the you know about the type of IPR you can apply for. Then it comes to how to approach it, where you will approach. You got the office also. You apply for the patent. You applied for the patent. You got the idea also how it will proceed. You filed it. It got published. Then it will go for examination. Then for grant. Then for again granted publication. So next is how to, what kind of application it is. If you are the filing the application, what kind of application it will be. So there are mainly three types of applications. One is ordinary, one is convention, one is PCT. So ordinary is domestic. If you are staying in India, and you are simply coming to patent office and applying for your invention, applying for the IP right, then it is called ordinary filing. In convention filing, it is group filing to the other country other than India. If you try to apply, uh, if you are trying to apply other countries from India, then you can go for convention. And PCT is a group filing. PCT is like at just there is a WIPO PCT, World Intellectual Property. So there you apply there, and from there WIPO they will ask you where do you want to apply, how many countries you want to apply for. So they will get all your information, and on behalf of yours, they will send to any number of country whatever you want. That is called PCT filing. And so if you are if you are, suppose you are an ordinary person, you are any individual person, just you want to file in domestic area, like in India only. So you will come with your application, but it should be mentioned in two ways. One is provisional and one is complete. So what is the difference between provisional filing and complete? So if there is one student or there is a scholar, so he want to apply for patent, but his work has not finished. He has done his half work and half is remained. So, and he is thinking, no, my work is not done, so I cannot apply for patent. But it's not like that. You have to apply it. You protect your date, priority date. We call it priority date. And you can apply in a provisional application. Provisional application will just, you will have to give some small detail about your invention, that you are doing this invention and these are the things we will be doing in our next future. After applying for provisional application, you will get a time period for 1 year, 12 months, and in between till the day from the date of your filing provisional to the 1 year, you have to complete your work and apply the complete specification. In that, you will have to give each and every detail about your invention, every detail with the drawing, and how many claims you want to claim about your invention, everything. So the thing is that I want to try to make you understand that even though your work is not complete, don't think that you cannot approach for application filing at IPR rights. You just go for it, and within 1 year, try to complete your work and go for the complete application. But there is one thing, that if you are not able to do that, file the complete specification, then there is also one option that you can extend your time, but your priority date will also get extended. Thing is that. So this is a very little bit deep, but just to be understand that, I want to make you try to understand that. Go for the protection right, and then try to complete your invention. That's all. So next we'll get to filing procedure, how we are filing it. So there is physical filing as well as e-filing, online filing, the submission of hard copy in the appropriate patent office through post or direct. So you can you can directly come to the offices, and or you can go through the post. Everything you fill the form and post it to the particular respective office. Next is how to do e-filing, like e-comprehensive file through portal. So this is we have one portal, IP India online.gov. There you can go and log in, and there you will get it, like you have to give which file, which form is there, your details, everything you have to fill there. So it will require your digital signature. I would like to tell you that if it is possible, please go to IP India online right now. Go through your phones, and just search it. And I promise you, you will get every little detail over there. Every section is separately, like patent is separately defined, your design is separately defined, and every section has its manual, right? So you can go to the manual, and they will it is disclosed in a very simple language, so anyone can get it. You can go there, download the PDF and read through it, and just go through it once. See, this will be the layout. You will see the ipindia.gov.in, the home, about us, who is who, policy, argument, everything is there. And if you want to contact us, your contact number is there. See, I told you every patent section, design, trademark, everything is displayed. You can go through all this act rules, manual guidelines, comprehensive e-filing, what is public search, what is journals, everything. Next is you go to that guideline and this login with this your username, password, everything. Yeah, that's all. So next is, if you are everything is done, you go, you know the you know about IP rights, you know where to file it, you know what is the procedure. You came to the office, you did the e-filing, but after filing, you did the filing, but what are the things you required for the filing of application? These are some mandatory forms you will have to fill it for further procedure. Form 1. Form 1 gives you gives us the details about you. Who is the applicant, who is the inventor, what is the contact details, where is the address we have to contact, and you know every small detail, your signatures, everything is very important. So just it is important. It is to be keep in your mind. Next is form 2. Form 2 is about your invention. Form is about you. Form 2 is about your invention. Form 2 gives it's like I told you, it can be a provisional or a complete specification. In there you have to you will have to fill each and every detail about your invention with your drawings and the details and the claims. Everything will be there in form 2. Form 3 is about a statement of foreign filing. It gives us the sense, it gives us the information about your filing. If you have filed in other country also, that is a form 3. It is also important form. You have to fill it. Even though if you are not applied it, just fill it and state there you have not applied for the foreign filing. Form 18 and 14, 18A is a request for examination. After the application got published, you will have to request for examination. Like you want to further procedure or not, then you have to you apply for the examination, and then it will come to us. We'll examine it. Form 5 is also a very important form. It is a declaration of inventorship. But if it is required, like you are an individual, you are an applicant as well as you are an inventor also, then you will not have to file form 5. But if you are an inventor, and on behalf of your college, your firm is filing an application, that is an applicant, so you will be the inventor. You will have to fill the form 5 to declare the inventorship. Form 9 is early publication. Like if you don't want to wait for 20 24 months for app publication, then you can apply for early publication, and within 1 to 2 months your application will be published. Form 26 is the power of attorney on stamp paper. If you don't want, if you want to file the application yourself, that is very easy, but you will have to go through the manuals, and just you will have to do your work. But if you are a busy guy and you don't want to file do everything on your behalf, you can go to a patent agent. Their patent agent are there for they will apply, and they will go through, they will communicate to the office on behalf of you. They will do everything. They will file it. They will write a claim. They will do everything. Whatever they can help. However they can help. They can help you. And to represent your power of attorney, your patent agent, which firm you have signed with, and who is an attorney general. So for that you will have to file 26. But if only you want to do it all the work, then it's not necessary to file Form 26. Next is proof of right. This is also very important form. Proof of right is the right given by the inventor to the applicant, that we are the inventors and we are giving this particular person the right to file the form of our invention. So proof of right is that. Form 8 is claim or request regarding mention of inventors as such in patents. Next is fees e-filing in India. So this is a basic fee. Like if you are a natural person, individual person, a startup or small entity, it will be basic fee will be 5 to 6,000. And if you are other than natural person, if you are a company, if you are a firm, if you are a college or institution, then you will have to basic pay is 28,000. You can go to the manuals. There, every detail is given. How many pages you have to pay for, how many claims you have to pay for, and how many free pages you can get, up to how many claims you can file for free. Everything is given. Go to the manuals in ipindia.gov.in. Expedited examination is there. There is one term, expedited examination. Like every after the filing for IP rights, you can apply for examination for it is a duration of 4 years. In between, in the 4 years, you want to give examination, you can give for the examination request. But if you want to, like early publication, you want to speed up your examination, then also you can do this. It is applicable for startups, small entities, and if the applicant is a female, they got a priority over this. It is just to encourage the female inventors, female scientists to this field, or joint applicant with other natural. If is a applicant is a female or a joint applicant with other natural person, then also they can go for the expedited examination. It comes into rule under 24C1 Patent Act. India as a ISA, IPEA in patent, PCT, Indian Search Authority is there, and an agreement between Indian Patent Office and a foreign filing. Next is we have our own platform to search our application. Like it is InPass. I would request you to go to this Intellectual Property India InPass. You can go through on this. Go to the link. Go to your Google. Ask Google. You will get the answer. And in InPass, you can search any application you have applied for, or if you want to see at what phase it is, my application is. So you can you can search by title or abstract or application number, patent number, applicant name, inventor address, anything. Everything is given, every attribute is given. You have to fill it and search it. Date is also given. So next is if you go for you will like if you are searching an application with your patent number, your granting patent number. So next you will get a display like this, and here you have to enter the code. So here you can see that it is filed or RQ request filed or published, it is published or it is under examination. Every status will be shown here. Okay, next is examination. Like examination is done. It is a formal examination and technical examination. First examination report, that is short form is FER, the gist of objections and communicated to the applicant. Subsequent examination on reply of applicant, check reply, re-examine, remove the objections which met the requirement, communicate a pending objection to the applicant. Then it will come hearing, then grant or refuse. Means after you apply for the examination, you give the examination request. There will be two types of examination that will be done by us: examiner of examiner of patents and design. Examiners is, it will come to formal examination and technical examination. Formal examination, so in formal examination you will see every tiny details of you that is given by you, your proof, your address, your proof of right, your details, your names, your address, your sign, uh, every mentioned detail we have given us. We have given the there's a, what we call that, patent agent numbers, everything. In technical examination, we'll do everything related to your invention. Like, we'll go through the search and we'll search about your invention. If it is there in entire world, we have our one platform where we search it, and we can search actually anywhere, in newspaper, in Google, in YouTube, any social media, anywhere, YouTube, anywhere. We will try to get similar what we call your similar invention. So, and if you find any similar invention like yours, we will make a report regarding that. It is already there, want to proceed it or not it, like this. So that report is called FER report, first examination report. That report will be sent to you, that is communicated with the applicant. Then you will have to give us reply, and reply, you will file a reply, you will send to the portal, it will come to us again, then we'll re-examine it. If it is satisfying all the objections or not, then it will be called for hearing with the controllers, and you will get a chance to tell about your invention, to convince them, to tell how your invention is different from other invention, how it is giving a technical advancement, how it is giving a new kind of advancement over that invention is already there, and advancement over that invention means it is hearing is all about you. People will be there to hear you. You will be there to tell about your invention, to represent that. Then after that hearing, there will be decision, grant or refuse. Next is what should be the patentability criteria. Everything is done. So for patentability, what criteria should be there? There should be novelty, inventive step, industrial applicability, invention not patentable under section 3 and 4. So what is novelty? Novelty is the invention should not have been published in India or elsewhere. Then it is novel. If your invention is totally original, then it is called novel. The invention should not have been in prior public knowledge or public use in India. It should not be used in public knowledge. Exception is there, but one exception is there. Display in public exhibition or paper presented before a learned society, but within 12 months, patent application should be filed. See, if you let's say you have done you have one invention of yours, and you did the public exhibition or a paper presented to the learned society, means the people who are directly or indirectly related to your invention, but within 12 months you will have to file, you will have to go for the filing. Otherwise it will be say like you have already published it and it cannot be patented now. Next is inventive step is there. What is inventive step? Inventive step means the features of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or both, that makes invention not obvious to a person skilled in the arts. The question is there any inventive step arrive if there is a novelty? it is means inventive steps means there should be a technical advancement. Even though, like you can see, you can take the example of mobile phone. There was a first Nokia mobile phone. You can see that there was a Nokia mobile phone, small one. So, but phone was there. The purpose was similar to communicate with the person which is far away from you, but technical advancement got there. No, every smartphone, then the smartphone comes. So that is called technical advancement. The purpose is same, but even though you are doing in some different way, that is giving the that invention a new thing, or it some what do you call that? Some new risen to the new level. That is a technical advancement, and it should have the economic significance. And should not be obvious to the person is skilled in art. Person is skilled in the art is mean to say that person which is related to the field of your invention. And next is that if your let's see your invention is novel. If it is novel, then it is inventive because it is completely original thing. So if your invention is novel, so you will have not to worry about inventive stuff. Next is third one is industrial applicability. It is a capable of industrial application in relation to an invention, means that is invention is capable of being made or used in industry. It means like your invention should be something like that that can be made and used in the industry, that can be taken to use to the person anything in the industry. Uh, there's a if you go through the ipindia.gov.in and they are in manuals, so you will get you will see or in act book you will see a section 3 chapter 2 invention not patentable, that invention which are not patentable. There's section 3 and some of the features are there which is not cannot be applied for a patent, like an invention which is frivolous or which claims anything obviously contrary or well established natural law. If it is natural law, like if someone say so earth revolves around the sun, it is known fact, it's a natural law, you cannot go for the patent for this. If it is about the gravity, this is a known fact, you cannot go for the patent. Next is like if invention's primary or intended use or commercial exploitation is which could be contrary to public order to morality or which causes serious prejudice to human animal, this cannot be also, which is prejudice to animal, human being, plant life, anything related to health or to the environment, that cannot be also patented. And something that a mere discovery, small discovery of scientific principle of or a formulation of abstract theory discovery, anything related to non-living substance occurs in nature. So these are the thing which is not patentable, like a mere arrangement or rearrangement of duplicacy of new thing. Like if some people do like this, some will be very over smart and they will do like this. They take five other inventions and take all the one feature from that invention, one feature from different, two features from different, and will make one new thing. So let me tell you, this cannot be patented. This is not patentable because it comes into section 3, section 3F, that is a mere arrangement or rearrangement or duplication of known device, each functioning independently of one another is known way. It's not patentable. Substance obtained by a mere admixture resulting only aggregation properties, like some chemical thing is also there, like if you are just mixing some mere some part of some mixtures and you make another one, then it is also not patentable under section 3E. Some method of agriculture and horticulture, presentation of information, topography, intellectual integrated circuit, mere scheme or rule or method performing mental act or playing games, like we can see that what we call the Rubik cubes. Everyone has their own way of solving it, but it is mental. It is mental performance. So it cannot also be patented. Like literally dramatical, musical, artistic work or any other aesthetic creation whatsoever, cinematography, television, the mathematical or business method. This also comes into under section 3K. It cannot be patented. Any mathematical thing is there or business purpose is there. This is also not patentable under section 3. Section 4 is very important section. It has directly linked to the government of India. The invention related to atomic energy comes under section 4. That is compounds of uranium, beryllium, thorium, plutonium, radium, many more. These are the dangerous compounds. So anything, if you are making one invention or a product, anything new thing, and you are using any of these compounds, then let me tell you, it will go directly to it will be referred to the Department of Atomic Energy, and their decision will be final. And no appeal lies on the order passed by the Department of. You could not do anything on the if the order is passed from the Department of Atomic Energy, so you could not appeal for anything. Next is a research paper versus patent. Like research paper is submitted to the journal. It is submitted to patent office. There are technical documents, but in patent, this is a techno-legal document. It is a combination of both. This is a manuscript. This is specification comes with a provisional and complete specification. I'm telling you this because see, some of the people they think like. The way you have the way you have written your resource paper, you cannot directly just copy and paste as a specification in the patent in Form 2. You will have to change its way of writing and way of describing it. So literature review and survey, it's prior art review, and there will be review on research paper, but there will be examination as per the patent and rules. Research paper gives you the citations and patent gives you the legal rights, documents during examination and gives you legal rights. There are some sections for anticipation. Section 29, anticipation by previous publication. Section 30, anticipation by publication, communication of government. At least 5 provisional applications prior to getting research paper published. When paper is established from that date, it will be in public domain, so that date will be considered for the anticipation, not the date of filing. Okay, next is the sufficiency of disclosure. Thing is that the complete specification must be sufficient to enable the whole width of the claimed invention to be carried out and also provide the best method for performing the invention. So here I want to tell you that many person thinks like this. They don't want to disclose their invention. They think like if they are disclosing it, then someone will copy in the patent office. Let me tell you, we are not allowed for that. We cannot do this. So no one should be afraid of that. Their invention could be copied after coming to patent office. So you should give a complete specification. It should be in the sufficient or enable the whole width of a claimed invention. It should be every detail, every tiny detail should be there. So we could understand it completely and we can make a good report for you. So you can come and get your grant. So see, if you give a broad scope and you will tell us to check it, how we'll do this? So you have to give every detail and in a good way, sufficiency of disclosure should be there, so we could understand and we could check. If we are going through your application, so we can understand your application. Next is a complete specification section. I told you, you have to write about your invention in your complete specification. And these are the sections you have to mention, like what is the field of your invention, background of your invention, or a prior art. You can disclose some prior art related to your work, but Also, how some of the this some how your invention is better than the prior art, how it is overcoming the lackness of the prior art, some other inventions. That is called a background of invention or priority art, prior art. The summary of invention should be there, brief descriptions of the drawings, detailed description of the invention, claim should be there, and the abstract. Which section of the complete specifications get protection? So uh, now the question comes under, if you have filed an application, then what are the section of your complete specification getting the protection, legal protection? So this is the part is called the part. The features were mentioned in claim. Claim protect is given over that and not to the complete specification. Complete specification is given to understand your invention, and whatever the new features, whatever the particular features of your invention is there, it should be explained in claims. So claim, the features mentioned in the claim, that will be given for legal protection. Next is the features mentioned in the claim shall be in the complete specification. So whatever the features you are whatever the features you are mentioning in claim, that should be in complete specification. Next is the claim set. It is an independent claim set and dependent claim sets. Independents are, this is the first claim, which is also called a principal claim. Like if you have a set of 10 claims and you have one claim is independent and others are dependent. So first claim should be independent claim, that is also called a principal claim, and every essential feature should be given in that claim. Next is the independent claim. It includes all the features of the independent claims with additional non-essential features. Whatever the non-essential features, that would be included in dependent claim. Next is the system. What is the system claim and method claim is there. So system claim is a group of things, part that work together, and method claim is the way of doing something. If you have created one, you have done one invention, that is a machine, like a mobile phone, or like you can see the Y in this anything like a phone. Let's give an example of phone. So phone is a system, is a group of things, or it has some application which works together, and the method is the way of doing something, how it is being done, that is called method. This is a small example of how to put your claims. So claim one is there, like there is one invention, that is a toothbrush invention. A tooth, so it is written here, toothbrush for teaching proper brushing technique. So it's whatever its main feature is given to the first claim, like it has a head and a plurality of bristles is there. There's a neck portion, there's a shank, elongate. It has a elongated handle body, and characterizes whatever what the shank is doing, neck portion is doing, elongated handle is there for what. Everything is written in claim one, and claim two is written that like this, the toothbrush of claim one, wherein the head, neck portion, and shank, elongated handle body are constructed from plastic. So they put that it has neck portion, shank, elongated handle in claim one, but what it is made of, it's plastic. So this is a non-essential part of this, so they put it into the plastic. Similarly, like this. So next is the certain statements are not allowed to be regarded as claim. There are some statements which cannot be put into the claim, that like statement of following forms are not regarded as claim. Like I claim to be inventor of this appliance. It's not giving anything about your invention. or anything, any feature is not given into this statement. Second is I claim a patent and that no one shall use my invention. These things should be not written in the claim, because this is not giving any important feature about your invention. You are giving information about yourself. You have to give information about your invention. See, third one is I claim that the machine described above is quite new as never. It is also not giving anything about your invention. These I claim some reward and I claim should not be made. So these are the things you should keep into mind while drafting your claims. It should not be written. It should not be right. It should not be written like this. Next is a basic timeline for how you are proceeding with it, every filing, examination, refusal, anything like this. So provisional and complete, it is your time is given for 4 months, 12 months. Like I told you, if you have given provisional only, because your work is not completed, so you will be given the time period of 12 months, and within 12 months you have to finish it and file a complete specification. Next is the request for examination. It is a 48 months, that is 4 years from your time of prior art, your date of prior art. Whenever you have filed a provisional or complete a specification, from that day to the 4 years, 14 months, in between that you can apply for request for examination anytime. Next is the reply to FER. You have to give the FER reply within 6 months. Form 3 should be submitted within 6 months. Form 5 should be submitted within one month. If you want to withdraw your application, then it should be given 15 months. But in 15 months, we can withdraw your application. There's a hearing submission for 15 days. Pre-grant opposition, it can come before grant, and post-grant opposition 1 year from the publication of granted application. Process to get a patent is a three basic process. Like you start and you made your invention, you made one product, and then device. Then step 1 is prior art search and summary written writing. So you got any idea, you started thinking, and then you got, okay, this is a very new thing, and I can go for the legal right. So, but for that, before that, you go for a search. Go for search in on Google patent, search on YouTube, search on Google, anything, whatever your medium, search it there. Try to search anything related to your work, your invention. Is there any invention similar to you? If it is not there, then draft the patent application. Draft it and file the application. Very easy. So after that, it is a sample of patent certificates that would be given to every person's. It is a certificate, patent certificate that will be given to the applicant or any inventor, whoever has applied for patent. This is a final thing actually. You will get a patent certificate. Okay, next is these are the search database. Those are free. That is InPass, Google Patent, eSpaceNet, USPTO, Patent Scope. You can take the screenshot of this and please go through it, all this patent search database, and I'm sure you will get some knowledge. These are paid database, PATSA, Total Patent 1, STL. For more information, you can go to the, as I told you, ipindia.nic.in. The manual of patent office practice and procedure, CII guidance is there. You can go to the ipindia.nic, manual patent. For some questions, query, you can go to ipindia.nic. These are the, you can go take a short, screenshot and go through it after the session. Now there are career opportunity in IPR also. Like file patents, design, copyright, license, royalty. You can become a patent agent also. Any science, any graduate background can become a patent agent. You have to give one exam, and there can be a patent exam agent. Patent drafting specialist also you can make. Patent analyst, work in trademark, copyright form, law graduate. For law graduate, they can work in trademark, copyright forms. IPR policy, IPR cell in institution cell, join government PR office. So this is a e-certificate for participating students. You will get a certificate from our NIPAM session. And this is a certificate for the participating college. I will send you this certificates, don't worry. Okay, so now if you have any questions, you can go for it. You can ask.
Okay, ma'am.
Yes.
If one of you have any queries, you can ask them.
Yes. Sorry, I could not hear you.
Sorry, ma'am. It was not a query. I was just asking if anyone has any questions. They can just ask it out. And we thank
Okay.
you.
Okay. So with this, thank you.
Thank you so much.
Very
Now,
great.
to propose word of thanks, I invite Dr. Rashmi Ravindran.
Good afternoon, all. On behalf of the Department of English, IPR Cell KAPILA, IEDC, and IIC MES Panani College, I would like to express my gratitude to all the participants who joined us for this webinar. We, the Department of English, extend our sincere thanks to the esteemed guest speaker, Ms. Ruchi Kumari, for sharing her valuable insights and expertise on this important topic. Her presentation was enlightening, informative, and engaging, and we are grateful for the time and effort she has taken to prepare and deliver it. We would also like to thank the organizers of this webinar, including the IPR Cell, KAPILA, IEDC, and IAC, for their efforts in bringing together this event. Their dedication and hard work have been instrumental in the success of this webinar. Finally, we would like to express our appreciation to all the participants who took time to attend this webinar and make it a success. Your active participation and engagement have been crucial in making this event a fruitful and insightful learning experience. Once again, thank you all for your participation and support. We look forward to your continued engagement in future events. Thank you.
Thank you, ma'am.
So you're winding up the program. Thanks, ma'am. Thanks you once again. Thank you so much.
Thank you. Thank you so much. So with this, we can end the session.
Yes, ma'am. Sure, we can.
Okay. Thank you. Thank you so much.
Thank you so much. We really enjoyed.
Okay. Thank you.